Good afternoon and welcome to the 43rd meeting of the Fair Employment and Housing Council. First, I'll have my colleague Kara Brodfear call the matter to order, please.
Thank you. Chairperson Sandoval. Chair Sandoval.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Hong.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Scher. Councilmember Scher.
Present.
Councilmember Walensky.
Present.
Councilmember Alude. And Director Kish.
Present.
There seems to be some noise interference, so if anybody could put themselves on mute, we would appreciate that. But I would like to welcome the public to this meeting. This meeting is being broadcast via Zoom video conference, and the video of this meeting will also be available afterwards on the DFEH website, as well as the DFEH YouTube channel. For those members of the public who are participating remotely in today's proceedings, please know that you are currently muted and your video is disabled at this time. However, please be advised, as in all other previous meetings, there will be an opportunity for public comment and participation throughout the meeting as we have addressed each agenda item. We have a number of ways for you to provide input and comments. You can send an email to the council at FEHCouncil, COUNCIL, at dfeh.ca.gov. We will be checking this email account throughout the meeting, and your comments will be read aloud and considered by the council members. Alternatively, you can use the Zoom chat feature to send a message directly to the meeting administrator who can read your comment out loud. Or if you would like to speak directly rather than through your written text, please click raise hand in the Zoom feature or press *9 if you called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename in the list of options next to your name. I'd also like to recognize individuals from the department who are joining us. Kevin Kish, who's the director of the department, as well as Kara Brodfear, the Senior Fair Employment and Housing Council. Thank you to all those who are attending. We look forward to your participation during today's meeting. First off, we are going to review the agenda. Please know that copies of the agenda and meeting materials can be accessed at the council's page of the DFEH website, which is the same page the Zoom video conference link can be found. Highlights today for the meeting include a report from the director, Kevin Kish, as well as a consideration of additional modifications to the housing regulations, and then we'll hear updates from the council's subcommittees. Our first order of business is a review and approval of minutes. So I would like this time to be provided to council members to see if you have any comments or edits to the minutes for our March 19th, 2021 Fair Employment and Housing Council meeting. Any comments?
None for me.
Do we have any public comments?
Kara, can you report on, I see nothing in the chat, whether we have any public comments that have come in otherwise?
No, Director Kish, we have no public comments that have come in, either by email or under the chat. Thank you.
Okay. Do we have a motion to adopt the minutes?
I so move.
You second?
I second.
Can we have a roll call, please?
Council Chairperson Sandoval.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Hong.
Yes.
Councilmember Alude.
Aye.
Councilmember Scher.
Aye.
Councilmember Brodsky,
Aye.
and Councilmember Walensky.
Aye.
Thank you, Kara. Next, we will have our report from Kevin Kish, the director of the department.
Great, thank you. And for those members of the public who are joining us, we recognize that Chair Sandoval is appearing on screen as Councilperson Shore. We are working on figuring out why that's so, and hopefully, there we go. If Chair Sandoval, you could potentially change your screen name to reflect your name rather than Dara's. I think we're ready to roll, and this will be an accurate public record for the generations to come. Just a few updates from the department before we jump into the business of the meeting. Since our last regulatory hearing in March, the deadline closed for large employers to submit pay data reports to FEH under SB 973. And if you recall, this is the law that requires employers of 100 or more employees to report demographic and pay data about their workplaces with the overall goal of reducing gender and race-based pay disparities. Employers who we believe have an obligation to file but did not do so should expect to be hearing from us in the coming weeks and months as we work to ensure full compliance with the law. I wanted to mention our sexual harassment prevention trainings. You've heard me talk about this before. This is another legislative mandate that DFEH produce and make available to the public sexual harassment prevention trainings in multiple languages. And I'm happy to report that since we launched the training in August, more than 600,000 Californians have taken the training, which is an average of about 70,000 a month. In the past month, at DFEH, we've released updated guidance for housing providers related to COVID-19, addressing some of the emerging issues, including information about obligations related to tenant-on-tenant harassment, as well as rent relief programs. We also, in May this month, issued guidance for healthcare providers and patients about reasonable accommodations for people with disabilities in healthcare settings like hospitals. And this includes guidance around visitors and support persons who provide assistance with communication or managing a patient's care. And finally, we have launched a portal on our website where members of the public can report to DFEH evidence of facially discriminatory advertisements and applications for both employment and housing, even if the person who saw the application is not themselves an applicant or does not want to file a formal complaint. And the idea of having a way for the public to let us know when there are facially discriminatory documents out there came from the Council's November public hearing on criminal history and employment and the Fair Chance Act, and the report from many stakeholders that they continue to see advertisements in the employment context that purport to exclude people with criminal history from applying. So I'm very pleased that we've launched that, and we'll be monitoring the information as it comes in. That's what I have to report today, and so I will turn it back over to Chair Sandoval.
Thank you so much, Director Kish. Does anybody have any comments regarding the report?
I
Council-
just
Oh, go ahead.
wanted to congratulate DFEH on the attention that your Cisco case is getting in the press, including in the New York Times article today. That was
In the
really,
Chronicle, yeah.
in the Chronicle, but really good.
And
This is
good work, and amazing work on all the stuff you just reported. But yes, that I agree, Dale. It's great.
And so for folks who are attending, this is pending litigation, so I won't be commenting on it, but the case involves allegations brought by a Dalit Indian and has prompted really a global conversation around the issue of caste and caste-based discrimination. So thank you.
Thank you so much, Director Kish. I unfortunately skipped an item, but I wanted to open it up to council member reports. If any council members have reports to provide at this time. Okay.
And
Well,
Chair
Mar-
Sandoval, we have one comment from the public regarding the last item.
Okay. We could address, it's a question that says, what is the question?
Oh, it's from one of the attendees.
We could address it, if you could tell me what the question is, we could address it at some other point during the day, but we'll address it.
Okay.
I will, if the attendee with the question would like to make public comment during the public comment portion of the hearing, then that would be fine. And I will also include in the chat our communications center email where members of the public can direct questions that aren't related to the agenda items on today's meeting.
Thank you, Director Kish.
Thank you. All right, so we're moving to the next item on the agenda, dealing with consideration of additional modifications to housing regulations. I'll turn that over to my colleagues, Council Members Dara Scher and Tim Iglesias. Council members.
Thank you very much. So first of all, we were very appreciative of all the comments on the last round of textual revisions. In this time, we made a couple of changes. I'll discuss part of them, and then Council Member Scher will address the rest. However, quite a few comments were made on parts of the text that had not been revised in the prior round, and therefore the council elected to, at this time, not respond to them. So the first change is on page 12 of the document that was accompanying the notice, and it regards evidence that is relevant to either a prima facie case or to rebut an affirmative defense against intentional discrimination. So it's in section 12042I, and we added the phrase evidence that housing opportunity remained available or was rented or sold to a person who is not a member of the complainant's protected class. This is a very standard in the law example of a type of relevant evidence. So we added that. The next one is on page 14 in section 12050G. This is in the section regarding discriminatory statements and advertisements. And we added in the section with regard to discriminatory notices, statements, and advertisements include, in the section where we talk about it's unlawful to use words or phrases that explicitly express a preference or limitation based on a protected class. We revised the reference to no children permitted to add, there was a parentheses that has to do with that does not apply when there is an exception for housing for older persons. And we revised that to read, except to state an age-based preference or requirement for housing for older persons, because some programs require that older persons, that only older persons be allowed to use affordable housing, and others don't make it a requirement, but allow the provider to make it a preference. So we made that change there. We also made the same change on page 116, or excuse me, 16, in section 12051E. And then we made on page 16 another change, which is in the section 12051C. And this is in the section regarding exceptions to liability for discriminatory, or for source of income discrimination. And for that, we added in the section C, which now reads, for a person to refer to a protected class, such as age, disability, and then we added or military or veteran status, when eligibility for a government subsidized housing opportunity requires the person to consider the protected basis. So that's just to incorporate more explicitly those particular programs. And then finally, on page, for me at least, on page 19, we made a change in section 12140B1. This is the section with regard to source of income discrimination. And in response to a comment, we revised one of the sections with regard to what types of income are considered lawful and verifiable, and basically changed the reference now at the end of that section to read, and any other payments recognized as income for federal or state tax purposes that are also lawful. So those are the changes we made in the earlier sections. Dara, you want to go ahead?
Sure. We also made some changes in response to comments in the sections relating to disability. The first of those is page 27. It's in section 12176F 8, capital B3. And the language, commentators suggest the language wasn't clear. And so we reframed it in more accurate terms. So the sentence in Roman numeral 3 now regarding what the request for an accommodation is now says Angelique requests both an accommodation withdrawing her eviction, an accommodation dismissing the unlawful detainer, which we decided was more specific and accurate than withdrawing her eviction. And in regard to the defenses, in the last sentence, we changed whether they're defenses to the reasonable accommodation request, we changed it to lawful reasons to decline either reasonable accommodation request. These just made more accurate and specific the nature of the requests. The next change is on page 33, section 12179, 12179 in section 12179C1. The word otherwise was deleted because it was a little confusing and not needed. On page 37, in section 12180B2, regarding the example regarding when an owner in a subsidized housing program has to pay for an accommodation to remove the carpeting, or a modification, a physical modification to remove the carpeting. And there had been a sentence there regarding restoration that was deleted because when an owner pays for the modification, there is no corresponding obligation on the tenant to replace or pay for any restoration at the end. That does not apply when the owner is paying for the modification. And then the next one is on page 41 in 12180 section, it's section C7, and it's an example. And we took out the language that says relating to assessing whether the request is necessary. That phrase was deleted because we had already determined earlier in the example that this is a necessary accommodation. That's sort of the basis of the facts. On page 42, in subsection 12181D, which relates to other requirements around reasonable modifications, this one is specific to common interest developments or, and homeowners association. And one of the commentators noted that the correct term for owners of those units is owners, not homeowners. That in terms of the statute that controls them, they're owners, otherwise known as members of the development. So we changed the term from homeowner to owner, which is also more consistent with the definitions in the document, which talk about owners, but not about homeowners. And I believe that those are the only changes we made in this round. So fairly technical corrections. So I believe now we're open for, I don't know what comes next, public comments?
Any council members, any comments or statements with regard to the regulations as presented by our other council members? Okay.
Sorry, this is Council Member Walensky. I had some non-substantive clerical suggestions having to do with cross-references that I wanted to just raise briefly.
Go ahead.
Okay. Sorry, I'm just pulling it up here. Okay, so looking at section 12055, little bb.
Give us a page number, please.
Oh, I'm sorry, I don't have, 1 second.
Oh.
I do have the page number. Sorry, I wrote it in a separate document. Little bb, it is.
That's okay, I can find it. Can you give us the site again? 12:05.
Oh, sorry. Yes, it's on page 8. Sorry about that. So it's towards the bottom of page 8, 12005 BB. In the first sentence, there's a cross-reference to sections 12005 T4 and T5. And I think those have now should move to 12005 V4 and V5, given the numbering.
And does the next section, which was U, change to?
I don't think so.
Okay, well, huh.
Oh, sorry. Sorry, because V4 and V5 are the definitions of the governmental entities. You're right, U, it looks like the U should also be updated, but I'm not seeing what it should be updated to right away.
W.
Thank you.
So I'm just confirming here. He moved to V and you moved to W. Okay, I assume that is a non-substantive change that we can make. Thank you for catching that.
Thanks, and I have a couple more similar ones going to section 12120 C7. Let me pull up the page. It's on page 18. And it's in subsection C7. There's a reference at the end of that subdivision to an exception set forth in section 12176 parentheses DB. And I think the D must be a typo, but I think it should be 12176E, which is the provision on confidentiality regarding reasonable accommodations and modifications.
me just confirm. It's so nice to have someone who's a really, really good proofreader. Thank you. B. You're right. B got renumbered as
E.
E. Yes. A, B, C, D, E. Yes, that should be E.
Okay, and I have a couple more, so bear with me. I'm looking at section 12176, subsection F6, which is on page, it's on the bottom of 25.
Mm-hmm.
And that is not a cross reference, but in line 1, 2, 3, 4, first word of line 5, it says, as a request for a reasonable accommodation that must be responded to. I wanted to ask whether it should say reasonable accommodation or modification to be consistent with the other addition of or modification in the other subsections.
Actually, I don't think so. This refers to requests for alternative assistance in completing forms or requests for alternative methods of communication. And so those would not be treated as modifications. So
Okay.
I don't think that change is correct.
Okay.
But I also thank you for referencing that. I think as I reread that section, it may need some changes in the future, but thank you. No, I don't think modification makes sense.
Okay, then I withdraw the suggestion.
Yeah.
And I have a couple more cross references. So let's see, or just similar clerical things that are non-substantive. So in section 12079,
You mean 179?
yes, sorry, 12179D. Sorry, I'm not pulling up the page number.
Probably 34 is my guess, 34 or something after that, right?
Yep, thank you.
Yeah, it's page 34.
Thank you.
And
So I'm looking at subsection D in the clause, so it's or whether a modification poses an undue financial and administrative burden under subsections 12179, just to change that to subsection singular
all right.
and add a space after the comma. And then on 12179E on the next page, on page 36, in the first sentence, there's a reference to under subsection 12179 B1 or E2. I think that's a change with the renumbering on the E2 because this is now subdivision E. And so I wasn't sure if that should refer to 12179 C2 little I, or whether it referred to a different subdivision.
So this relates to fundamental alterations. So the reference to B1 is still correct.
Right.
And then Well, let me look at the other one, which was E2. So, which was, fundamental alteration. Trying to look where else we talk about fundamental alteration.
Yeah, I'm looking, so in section D, in the first, moving up to section D, the cross-reference is to 12179 C2 little I. So I wasn't sure if that was the right
No,
cross-reference or not.
A recommendation, any cross-referencing changes are not substantive changes to the regulations and don't actually have to be moved through a public hearing. So if we just want to list them and the reasons for them, then we at DFEH can take a look to see if we actually should be making those changes and make them without needing to do it in the public forum.
Great, thank you. Yes, we should take another look at that second one there on page 36 that now says E2. We need to check that one. The first site, 12179B1 is correct.
Okay, and thank you so much for that, Director Kish, because I recognize how painful it is to go through this in the meeting. So just the last thing I wanted to ask, which is not a cross-reference, it's in section 12181M. And that is on page, sorry, I'm losing the page here.
45.
45. Thank you. And it was just a question, which is toward the bottom of M, the language. It says, in addition, the developer must consider the request as one for reasonable modification under these regulations, including engaging in the interactive process under section 12177 is needed. And I noticed that the interactive process language had been cut from some of the other examples, and I wasn't sure whether the subcommittee had considered cutting it from this one as well.
No, I think it's appropriate under this particular one. We don't have facts stipulating that, you know, that this is appropriate. It would need to be considered as part of the interactive process, but thank you for catching that. It's nice to have two people who read really closely. Now we have several. So welcome to the club. You're in good standing with Dale and others who we really appreciate for their very careful reading. So thank you.
Yes, thank you very much.
Do any other council members have comments with regard to these regulations? Okay. Any public comment?
Yes, Chair Sandoval, I'm going to unmute Heidi Palutke. And Heidi, you can make your public comment now.
Great, thank you. This is Heidi Palutke on behalf of the California Apartment Association. My comments are going to focus on two issues we raised in our letter of April 7th that were not changed in today's draft of the regulations. First, I'd like to thank the council for addressing the issue we raised with respect to the definition of lawful verifiable income by modifying the text to ensure that the income has to be lawful in addition to being taxable. We don't want to give the Al Capones of today source of income protections. So the first issue is in section 12141a, the examples of adverse action. Paragraph A1 provides that refusal to negotiate in good faith with the provider of any public assistance, rental assistance, or housing subsidy program constitutes adverse action. In our most recent comments, I raised the concern that this may require the landlord to do something that was actually rejected by the legislature in passing the law that extended source of income protections to Section 8 recipients. That legislative intent appears in 2 bill analyses that I cited in my prior comments. Specifically, the way that we read this provision, it appears to require the landlord to negotiate with the public housing authority regarding the rent in good faith. This is a situation that would arise when the unit's rent is more than the voucher and the tenant's share of the rent will cover. So to me, in good faith means that you enter the negotiation willing to compromise, willing to give something up. Otherwise, that whole negotiation is really a sham. That may not be what's intended here. So my question for the council is, are you taking the position that landlords are required to negotiate a rent decrease or other changes to significant terms of tenancy with the housing authority in order to avoid source of income discrimination? And then also, it would be helpful for me to understand this provision if you could provide some examples of what negotiate does mean in this context.
Negotiate does not mean that the owner is required to get to any particular outcome. So let me just say that. It does mean that they have to consider the alternatives that are being, you know, what negotiate usually means. You listen to what the other side says and you think about what's reasonable and what changes you might be willing to make. And I can say there are circumstances when Section 8 rents, where there could be negotiations around rents when a tenant is seeking exception rents or some other things. So where the landlord may need to be involved in some discussions about how that gets played out. That does not necessarily mean they have to accept a lower rent than what's advertised for the unit. It just means they have to negotiate, which is a requirement in the statute, the FEHA itself, that they have an obligation to negotiate. So I think we flagged that in our, so I think that's what it means. And I think this is appropriate and does not conflict with the legislative intent. I don't know if you want to add anything, Councilmember Iglesias.
No, I think that's good. Thank you.
Thank you. That's helpful. On the only other comment I had has to do with section 12141B, which relates to inquiries concerning the level of source of income. This provision states that it's not discrimination based on source of income for a landlord to make a written or oral inquiry concerning the level or source of income for certain listed purposes. That list that's provided does cover most of the reasons that a landlord would need this information. However, I could think of a couple other reasons off the top of my head when I was reviewing this the other day. For example, the landlord might need to make this inquiry to verify whether a tenant is disabled and entitled to a reasonable accommodation, since those disability payments may be how the tenant verifies their disability. And then another issue, which something I've been spending a lot of time on recently, is the landlord may make this inquiry of their tenant to determine whether the landlord should apply for emergency rental assistance for that tenant, which would certainly help a tenant who had COVID-19 related financial distress avoid eviction. The issue here is that the law doesn't really contain any limitation on the purpose for which these inquiries can be made. It simply says it shall not constitute discrimination based on source of income to make a written or oral inquiry concerning the level or source of income. So our suggestion is that the regulation should instead restate the broad language that's in the law and then cast the provisions that are in there currently as examples of inquiries that wouldn't violate the law. The law also doesn't limit the inquiry that can be made regarding level or source of income just to inquiries by landlords, just as it doesn't limit liability for source of income discrimination to landlords. For example, section 12955E of the government code prohibits source of income discrimination by banks, mortgage companies, and other financial institutions. these entities would definitely need to make inquiries about the source and level of income of a tenant who is hoping to buy a home. So the prohibitions based on discrimination, based on source of income, apply to a lot of different entities and not just in the landlord-tenant context, although obviously that's what CAA is the most concerned about. So for that reason, CAA proposes that this section be revised to omit the reference to landlords and to provide examples of when an inquiry can be made rather than an exclusive list. And also that list of examples includes some that occur outside the landlord-tenant context. And we can certainly provide some proposed language in the written comments that we will be submitting. And those comments will likely be on behalf of both CAA and also the California Association of Realtors.
Okay, thanks. To address your comments, first, with regard to, yes, it's absolutely true that source of income discrimination refers to all kinds of other contexts. In this particular set of regulations, this set is only referring to landlords, and that's why the section title of that area is about rental discrimination. So that's why there's a reference only to landlords and landlords agents with regard to those. But you're absolutely right, and the I believe the council will want to address the other instances and contexts for source of income discrimination in a later set of regulations, perhaps. And then with regard to your examples, I don't think the statement of, well, first of all, big picture context. As you know, FEHA is a remedial statute, and the legislature and the courts have regularly emphasized that a remedial statute should be interpreted very broadly, and therefore an exception to a regulation or some kind of liability ought to be construed narrowly. So that's the basis upon which we're proposing to limit the scope of this set of exceptions. And I believe that the examples you gave would certainly still fit within the catch-all of as required by law there. So I don't interpret there being a problem with those additional examples you came up with.
I'd like to offer a process-related comment, if I may. I just want to remind both the council members and the public that the draft that we're discussing right now was produced in response to a second 15-day comment period. So to the extent the council members, the proposal today is to move a revised draft into a third 15-day comment period. To the extent the council members want to make changes in real time, that's permissible to go into this third comment period. But of course, we encourage members of the public to submit formal comment during that period, and I wouldn't want to prejudge council's response to that comment during the deliberative consideration of those recommendations. And any exchange, of course, would only become part of the public record during the formal comment period and the council's response to that comment period. So I'm very grateful for all of the back and forth, but I just want to flag that it's important that it actually be included during the comment period.
Great, thank you.
Thank you. Councilmember Hong?
Yes, thank you. As a process question, so at the third round of comments, are they only allowed to comment on the changes that we just made, or is it of the entire? It's just so that I have a better understanding of, because I reviewed all the public comments as well. And so I just kind of want to know what the format is.
Sure, and this is a good example of we do this work in real time in public. So it's a learning process for us all. Members of the public and stakeholders, of course, can make any comment that they want to make in response to a draft during the public comment. But the obligation of the council is to respond to those comments directed at changes during the last round. So it is not a technical requirement to respond to each and every comment that comes in if those comments are not responsive to the most recent change.
Thank you.
Any additional public comments, Kara?
Yes, Chair Sandoval, I'm going to go ahead and unmute Renee Williams.
Hi, can folks hear me? Okay, great.
Yes, go ahead.
Hi, thank you so much. My name is Renee Williams. I am a senior attorney at the National Housing Law Project. And again, just want to echo what others have said in terms of thanking the council, for their care and attention and work on these really important regulations. I just wanted to flag an issue that is covered by the substance of the regulations, and just flag it in terms of some feedback that we've been getting from other housing stakeholders. And it's this idea of when there are preferences that benefit members of protected classes. And I do know that in the proposed regulations, there is the standard that lays out, avoiding liability for a facially discriminatory policy. So something, where there would be a preference, for example, for members of particular protected classes. And then it lays out the test from I believe is the Community House case in the Ninth Circuit. And so, with respect to that, just wanted to flag this sort of broader issue of, for example, if a housing provider wanted to have a preference for voucher holders, just as an example. And so just thinking about, whether or not there are ways to connect this issue of when there is a policy that objectively benefits a protected class, and how that relates to, for example, express statements and those prohibitions, as well as, the source of income provisions later in the regulations, and just making sure that there is some connection between the two, because I think as I read the draft, there is this statement about, for policies that benefit protected classes. And then I don't think, and I could be wrong, and if I am wrong, please correct me. I don't think that piece is unacknowledged in other parts of the regulations that may be relevant, like discriminatory advertisements or some of the source of income provisions and the exceptions to the source of income provision. So I wanted to flag that issue. And again, just really thank the council for your work.
Thank you very much. It would be very helpful if you wanted to put that in a written comment and contextualize it, just sort of to really emphasize and make sure that we can keep that in mind.
Sure. And, it is a very nuanced, discussion. And so, yeah, I would be happy to provide that a little bit more in writing. But I just wanted to flag the issue here. And again, to council members Iglesias and Shore, just again, thank you so much for all of your work on these regs. Thank you.
Thank you, Ms. Williams. Any additional public comment, Kara?
We have one more. Cornelius Cannon, I'm going to go ahead and unmute you now. Mr. Cannon, are you there?
I'm here.
You can hear you, Mr. Ken. Go ahead. Has he been unmuted? Is there a technical difficulty?
It looks like Mr. Cannon is unmuted and he should be able to be making a comment. Let's see.
Based on the chat that has been sent to all of the participants, Mr. Cannon may have an inquiry that's not related to this rulemaking. So I propose that we continue forward. And if he still wants to comment, he can raise his hand again so that we can unmute him.
Thank
Okay,
you.
and there's also additional public comment periods as part of this meeting. Any additional public comments, Kara, Rob here?
No, there are no additional public comments in the chat over email or on Zoom.
Okay, do we have a motion for council action?
I move to advance this draft. I move to advance this draft for further comment.
I believe Councilmember moved the draft be again considered by the public for another 15-day period. Is that correct, Councilmember Brodsky?
I think that's what's being asked, and yes,
Yeah.
that's the motion.
Great. Oh, I just wanted to make sure it was clear on that one. And then we got a second from Councilmember Alude. Thank you. A roll call, please.
Okay, Chair Sandoval.
Aye.
And Councilmember Brodsky.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Hong.
Aye.
Councilmember Alude.
Aye.
Councilmember Scher.
Aye.
And Councilmember Walensky.
Aye.
Great. Okay, so the next item on the agenda is to get an update from the Reasonable Accommodations for Associational Disability Subcommittee. We have our council members, Dale Brodsky and Adetunji Alude. So council members.
Thank you, Dale. I'll go ahead and feel free to fill in if I miss anything. So the council put out a request for input from the public regarding the proposed regulations on associational disability, and we received numerous comments in response. The subcommittee since then has carefully reviewed and is synthesizing those comments. So their work is very much in progress, but right now we're working on sort of how we want the proposed language to look, and are hoping to have something to present at our next meeting.
Thank you, Councilmember. Councilmember Brodsky, do you have anything to add to that?
No, that covers it. Thank you.
Thank you. Any comments from our council members? Any discussion?
Sounds like great work. I look forward to what you propose.
Thank you. So do we.
Any other council member? Okay. Any public comment, Kara?
No public comment.
Okay, thank you so much. We're
I
gonna move.
apologize. There is someone with their hand raised in the chat. Rachel Langston.
Thank you, Director Kish. Rachel Langston, I'm unmuting you now.
Thank you very much. Legal Aid at Work. I'm Rachel Langston, a staff attorney with Legal Aid at Work. We're a nonprofit legal organization that advocates for the rights of low-income workers and their families. We again want to thank the council for its work regarding these important regulatory modifications. Of course, we maintain that this right exists already under the FEHC, but the employers that we hear about regularly deny the accommodation requests. So we frequently hear from workers struggling to balance their jobs while providing assistance or other care to a relative or other associate with a disability. These regulatory modifications rather would go far in enabling us to more effectively advocate on behalf of both people with disabilities and their associates. So thank you again very much for your work on this issue.
Thank you, Ms. Langston. Any additional comment?
Yes, we have another public comment from Ashley Hoffman. I'm gonna allow you to speak now.
Good afternoon. Can you hear me okay?
We can hear you fine, Ms. Hoffman.
Great, thank you. This is Ashley Hoffman on behalf of the California Chamber of Commerce. I just wanted to ask a clarifying question. It sounds from the subcommittee's report that they have affirmatively decided that this right does exist under FEHA as it stands now. As we stated in our submitted written comments on behalf of us and others in the business community, we do not think that this right presently exists under FEHA and that it was not the intent of the legislature to extend reasonable accommodations to associated disabilities when these laws were originally passed. So I just wanted to clarify if this means that the committee has decided that that right exists, or if this would be essentially a new right that they would be putting into regulation.
We are reviewing the comments that have come in, and we have not submitted anything to the council at this point. So there is not anything yet for the council to consider or not consider. So it is a work in progress, whichever way you want to view it as a work in progress.
Okay, thank you.
Thank you, Ms. Hoffman. Any additional public comment?
We have a short comment in the chat that I'm going to go ahead and read.
Okay, thank you.
This is Alan Goldstein, attorney with SEIU Local 1000. We appreciate the opportunity to submit comments. We strongly appreciate the council looking at the issue as it could be vital protections for all households containing people with disabilities. And he asked the question, will the public comments be available publicly?
Director Kish, maybe you can answer that question because we don't have any, there's not a draft of regulations, and normally how the process works is that once there's a draft of regulations and the council approves the draft, then it's open to the public for making public comments. So to the extent that there's been, that's how the process normally works. Do you want to add anything to that?
Can I just say, it's not clear if that's what they're asking about or if they're talking about like a transcript or stuff from the hearing.
I think I understand the question, which relates to the comments that we solicited from the public on this question. It's true that there is no pending regulatory action, so there is no formal public comment period. We have not posted those comments publicly, but any communication that's not case related or privileged that comes to the council or the department is actually subject to the Public Records Act. And so as I sit here today, I don't know if those comments will or should be posted, but they are available to the public via the Public Records Act.
Thanks, Director Kish. Any additional comment, public comment?
No, Chair Sandoval.
Okay. Thank you, everyone. Thank you, council members, for your work on this. We're moving on to the next update from the Criminal History and Employment Regulations Subcommittee. We have Councilmember Walensky who will be providing an update today. Go ahead.
Thank you. So the subcommittee plans to propose an amendment to the regulations on the use of criminal history and employment decisions to ensure that employers comply with the Fair Chance Act when determining eligibility for the federal work opportunity tax credit. And the second update is, as a follow-up to the council's hearing last November, the subcommittee is exploring potential amendments to these regulations that would further effectuate the Fair Chance Act. Chair Sandoval and I have spoken with several of the experts who participated in the hearing, and Chair Sandoval and I also attended a virtual Know Your Rights community event from the Inland Empire Fair Chance Coalition and Legal Aid at Work. Thank you. Anything to add, Chair Sandoval?
No, I'm fine. Thank you. Any additional council members like to make a comment or add to this? Okay. Do we have any public comments?
There are no public comments, Chair Sandoval.
Thank you. Okay, so we're moving next to the next update, which is the Government Code Section 1135 Regulation Subcommittee, headed by our council members Dale Brodsky and Derek Scher.
Thank you, Chair Sandoval. We are still in the process of working with the various review agencies on the review process of the regulations. We do not have a date yet for when that review will be completed.
Thank you, council member. Do we have any comment or discussion from other council members on this item? Any public comment?
No public comment, Chair Sandoval.
Okay, we'll proceed to the next item, which is an update from the Hate Violence Subcommittee. Councilmember Brodsky, would you like to provide an update?
Yes, thank you. Well, both Chairperson Sandoval and I have attended bystander training sessions, I should say. And we have been thinking about how to incorporate that into the sort of follow-up to the hate violence hearings that the council held some time ago. And we're hoping to be able to have a training actually be part of a council meeting if the council agrees to that and think it's a good idea. And that was the trainings that we attended were produced by a group called Hollaback. And it's an international, they do international trainings, but they're specializing right now on training folks. I think they said they trained 80,000 people, might be off on that. It's either 40 or 80, I can't remember, but it's a lot on how to kind of open our eyes to what bystanders can do in the situations where hate violence is occurring, and we're observing that. And it was really a wonderfully productive training session. I found you can, and in terms of offering levels of interaction, levels of involvement, and really giving both exposing the problem, but also then giving people information on how to deal with it when it happens in front of you. So that's where we're going with it. Part of what we would like to do is as a follow-up to the hate violence hearings. Gabriel, do you have any more to add to that? Because you were really the instigator of that, and I appreciate that.
Thank you, Councilor Brodsky. I think it's important to really recognize there's been a surge in hate violence against Asian Americans, Pacific Islanders. There's been a growing surge of anti-Semitism, and of course, other community groups continue to be targets of hate incidents and violence, whether it's the LGBT community, the Latino community, and others. So one thing that Councilmember Brodsky and I talked about was providing an opportunity for members of the community to be trained with regard to bystander intervention, and what are some affirmative ways we could work together to ensure that we're reminded that we are our brother's keeper, we are our sister's keeper, and trying to intervene in a positive way to make sure these types of conduct in the communities come to a stop. So we did participate in bystander training, and we're continuing to think through, and hopefully we will have, as the councilmember mentioned, a training in the foreseeable future for the broader community on this item. Any council member discussion or comments? Okay.
Oh, actually, I do.
Chair
Chair Sandoval, I know in the beginning that they were actually getting overbooked. It was so popular. I think people were they missed their windows. I think having it, offering it is a great idea, because I've just heard incredible positive feedback about the Hollaback trainings. My only question is whether or not there's a way, I don't know if they don't do any MCLEs, if there's a way to encourage professional like credit in order to engage people or incentivize people to actually do this along with their children or their family members as well.
We're actually looking into that. That was one of the suggestions we made. And there are, as you probably know, there's certain requirements that have to be met for continuing legal education. So we'd have to make sure that that could be built in. I don't know that it could. Having taken the training, I'm not sure that it lends itself to it, but maybe there is some specialized ways it could be. But I agree with you. I think that would be an added incentive. And certainly, you know, everyone needs to be trained, including lawyers. So.
Yeah, we're looking into that. And the training that I attended was held back in partnership with Asian Law Caucus and Asian Americans Advancing Justice. But perhaps absolutely an elimination of bias MCLE credit would be great. Okay, any public comments?
We have one public comment in the chat. I'm just going to read it out loud. It says, Dale, I would like this training to be open to the public.
Oh, the idea that we have is that it certainly would. I mean, if we could incorporate it into one of our regular council meetings, it would be open to everyone. So absolutely. And Hollaback is a nonprofit organization that it operates on donations, but it provides these trainings for free. So, you know, absolutely.
That's the intent, to open it up to the public.
And then I would just offer up, I have contacts at California Lawyers Association. So if you wanted to see, because they're doing a lot of work in the racial equity space. And so if we wanted to see if they would be a co-sponsor for that MCLE credit, just throwing it out there.
That'd be wonderful. If you could, you know, follow up on that, or you want one of us to do that, that would be great.
I think to avoid any Bagley-Keene issues, probably the best thing would be for Councilmember Hong to tell us what to do, and we will do it.
Great.
But just to clarify,
the department.
Yeah, DFEH is an MCLE provider. The question is whether the content of the training meets the requirements set by the state bar for MCLE credit.
Thank you, Director Kish. Any additional public comments on this item?
No additional public comments.
Okay, so now we'll hear from Council members Tim Iglesias and Councilmember Helen Hong with regard to the Algorithms and Bias Hearing Subcommittee.
Well, as you all know, we had a productive and well-attended hearing almost a month ago. We had almost 271 people attend. It was very content heavy with a lot of, I think, opinions from academic, social justice advocates. And I do want to recognize the DFEH staff who just put together an incredible panel. We have reviewed and we are continuing to review the public comment. One of the things that we wanted to really get your input on today were your thoughts about possible next steps. As you can recall, many of the speakers gave us a list of what not to do and what to do. There wasn't a lot of, I would say consensus, and it kind of went all over the board because we were talking about AI bias in healthcare, financial institutions, employment, and in housing. And so with that, part of this is before we go back as a subcommittee, we really wanted to get your thoughts and inputs based on all your respective expertise about suggestions for next steps. And so while you're continuing to think about that, for me, for one, is I would kind of like another hearing, partly because this is a very technical and a new area. And I was really wanted to hear from Meredith Whitaker from AI Now, from the industry side, in terms of her input. So with that, I did want to open it up to see what your other thoughts and reactions were and possible next steps from the council's perspective.
Well, I wanted to first thank again the DFH leadership and staff that put the particular committee and hearing together. But I do think that there was a lot of more questions that were raised than answered for a variety of reasons, just because, as we heard from our expert panelists, there's not a lot of regulatory work that's being done at the state level or at the national level, although there is a lot of concerns that are being raised, right, that this may be having a disparate impact on certain individuals. So I think, generally speaking, it would be good to kind of figure out what is the lay of the land in terms of the law, what is existing law or not, and kind of catalog that has an impact of these types of algorithms that are being used. And so that we have kind of a white paper or just items in terms of case law that have touched upon this issue in a very succinct way. That would allow us to have, I think, a more focused meeting, and maybe have the meeting related to the issues that we deal with. So maybe in the next several months, but before that, I think it would be important to get some kind of white paper or some kind of legal research of here's what's being done in this federal level, if anything at all. I know there's been convenings already at various committees, but what then? And then any states that are really addressing this particular issue. So those are my initial thoughts.
Go ahead, Dale.
I was just going to ask, I have a question for Director Kish. In the data that you're collecting on job applications, is there anything that comes out of that that's related to the selection process that is the algorithm stuff?
Well, the portal for folks to submit complaints just launched this month, so we don't have any kind of, I believe a handful of items have come in. I have not personally reviewed them, so I don't know what they show, but I'm certain that we don't have anywhere near kind of a sample of everything that's out there at this point in the project.
I wonder if there's any questions that could be posed on that portal. I don't know what it looks like, so I don't know what the format is, but that would alert people to, if they believe that they've been subjected to discrimination by having been filtered out of a system that relies on algorithm. I don't know. It's just a thought.
Thanks. Our project, the one that I discussed earlier, is one that focuses on facially discriminatory ads and advertisements. So I think this would be something a little different, but it's certainly something that we can talk about.
So I think all these ideas are great ideas. It was a wonderful hearing. I learned a lot. I like the idea of having some framework in terms of what's being done on a regulatory or statutory basis around the country. I would love to hear in the next hearing, if we do it, a little more about housing and lending than we did. I've previously given Kara some contacts who I've heard do some training on this, who I think are really good and are working at a national level. And I learned some things from them, and I just still have lots more questions about how this impacts credit reporting for tenants and how landlords make determinations about which tenants, you know, how these are used in tenant selection and how they are used in marketing and marketing of rental units, and how they are used by real estate sites and other apartment sites to steer people. And I would really like to hear some more about those things if we have another training. Or another hearing. Yeah.
Thank you, Council Member. Any additional discussion or comments from Council members? Councilmember Walensky.
Thank you, Chair Sandoval. I want to echo the thanks that others have expressed to the council members and DFEH staff who put on the hearing. I thought it was wonderful and I learned so much. I also came away with a lot of questions. And in addition to the other areas folks have mentioned, I would also be interested in learning more about the use of algorithms in state-funded programs in California, especially in the child welfare system and other state-funded programs.
Thank you, Councilmember.
Oh, you're on mute, Gabe Sandoval.
Any additional comment from our council members? Okay, public comment.
We have one public comment from Mr. Cannon, but it appears that he's unable to speak due to a technical difficulty. So I would encourage him to send his comment via chat or email.
Okay.
And no other further public comment.
All right. Thank you, Kara.
Thanks, everyone. That was very helpful. We're trying to get our arms around this. Is pretty big stuff. So thanks very much. It's very helpful.
Thank you.
It was a great hearing, by the way. It was really, really good. Thank you so much.
Very interesting and informative. All right, so let's now speak on the last item on the agenda. It's a discussion of additional subcommittee assignments. Do we have any discussion by the council on that? Okay. Any public comments?
No public comments.
Okay, do we have further public comment?
No further public comment.
Okay. I would like to adjourn today's Fair Employment and Housing Council meeting in the memory of the Honorable Cruz Reynoso, who unfortunately passed away on May 7th of this year. Justice Reynoso, the son of Mexican immigrants, was the first Latino to serve on the California Supreme Court, having been appointed by then Governor Jerry Brown in 1981. He also served on the U.S. Commission on Civil Rights as its vice chair and was the recipient of the Presidential Medal of Freedom. The Honorable Cruz Reynoso was a social justice warrior and trailblazer, and indeed a mentor for many of us inside and outside the legal profession. He was the quintessential public servant who instilled in all of those who worked with him and who knew him that a profession should be used to help the marginalized and to speak out and defend their rights when others, particularly those in power, chose to remain silent. May Justice Cruz Reynoso rest in peace, knowing of the positive impact that he made on issues of civil rights and social justice for years to come through his life and through his example. Have a good afternoon, everyone.
Bye. Thank you very much.
Can we just formally, gavel us out with our magic language?
I'd like to adjourn this meeting.
Okay, meeting adjourned. Thank you, everyone.
Bye, everyone.
Thanks, Rich.
Bye-bye.
Have a good afternoon,
Thank you.
Bye-bye.